Welcome to the It's Been Said podcast. I'm your host, SAI Executive Director Lisa Ramey. Today's episode is a special edition of the It's Been Said podcast. Matt Carver, Legal Services Director, will discuss his perspective on current legal topics relevant to district and school administrators. He'll offer his insights on this subject matter periodically over the coming months. Let's hear from Matt.
This is Matt Carver, and this is SAI's Legal Vortex. Well, today I want to talk to you a little bit about a topic with which I've had a bit of a love-hate relationship, I guess one might say, over my 20 years at SAI, and that concerns the topic of liability. When should schools be worried? When should school employees be worried relating to liability? And then importantly, and this is probably one of the big points that I want to make on this podcast, when should you not be worried? When should you not be as concerned, where maybe you can settle the nerves, especially of your employees, relating to their worries about whether they are going to be liable for their actions as an employee in your school district. So I want to go over some of the high points, and hopefully this helps to sort of clear things up a little bit. I'll start with talking from the district level, so from the employer level, and some of the things that help to protect Iowa school districts relating to liability or the potential for liability. And with that, there's something in our code called the Iowa Municipal Tort Claims Act. This act protects certain public employers here in the state, to include school districts, in a number of different areas. And it's really important, these areas where it protects you from the potential liability when a student gets hurt, maybe a visitor gets hurt, there's some injury that occurs at your school. And some of those areas include the discretionary function. And so that's the first one I'll talk about. And discretionary function relates to situations where decisions are being made by the district relating to things like what curriculum you choose. Okay, so what classes you're choosing and the type of instruction you're going to have. And of course, you might say, well, how would that come into play? Well, it would go to certain areas. Obviously, you have some of your classes where someone might argue there's a greater likelihood of potential injury with some of the things you do. You know, a common one I'd say is in your shop classes or other things where students might be using certain equipment or technology that might potentially injure them in some way. And so you generally have some immunity there as a district, as long as you're following good practices with developing that curriculum. You're considering these things as you develop the curriculum, deciding, well, this just seems to be a bit too dangerous for us, or no, these types of activities in our curriculum wouldn't be as dangerous. So that would be an example of a discretionary function. Another one would be, well, how much supervision do we have? And this is really a big one. And I'll talk quite a bit on this podcast about supervision. You know, that's also considered a discretionary function relating to how much supervision you have for your students you're building. Now, of course, you know, we could go to the extreme of this and say, well, we don't want there to be any injury, and so we're going to, and of course you can't do this, you know, the funds to do this, but we want to have a one-to-one for all of our students in our school district, and that's going to provide the best supervision, or maybe 2-to-1. You're going to have 2-to-1. We have unlimited funds, and so, well, that's just not going to happen. And so with that, the standard that would be placed on you, and you'd have protections there, is you're using reasonable practices to determine as a district, well, what is sort of the standard in the broader educational community relating to supervision? And of course, that's going to vary a bit based off of the activity or based off of things perhaps that have happened in your districts in the past, or certain buildings and so forth. But as long as the district and leaders make decisions that are reasonable decisions concerning that supervision, then this Iowa Municipal Tort Claims Act would protect the district from liability if someone alleges, well, you didn't have enough supervision there. You should have had more. And that's something that the court's going to consider in those instances. Another area of protection for the school district relates to recreational activity immunity. Okay, so this might do with sports. It might relate to particular sports that you have. It could relate to things that are done possibly in PE class. It could relate to things at recess, and that there's a bit of an assumption of risk, one might say, when students participate in certain activities. Now, obviously, with younger students, that's why it's all the more important that you might share, well, these are some of the activities we're doing. This is what our curriculum, you share your curriculum. These are the types of activities we do in PE, or these are some of the games perhaps that we allow at recess, and other games, of course, you might not allow because historically you found that there have been more injuries there. But assuming they have some awareness of this, again, there's an assumption of risk when they participate in these activities. You have basketball, that'd be a common one on the playground. And anyone who's played basketball or been around basketball knows on occasion someone's probably going to go up for a layup or jump in the air, and they're going to come down and accidentally step on someone else's foot and twist their ankle. Or maybe worse, maybe it breaks their ankle, it breaks a bone in their foot. So would the district be liable there? Well, likely not. And the reason why the district would not be liable, again, relates to this statutory immunity relating to recreational activities. Students participating in football, and they go out and they have some sort of injury relating to their participation on the high school football team or the middle school football team. Well, why is the district not typically liable there? It would relate, again, to this recreational activity immunity because there's some assumed risk there. Another area relates to design and construction for recreational facilities. So as long as the district was following, and this would go to things such as, what's used, what are the types of things that are used in PE class. This particularly goes into areas relating to recess and playground equipment. So as long as the district in good faith was ensuring that whatever was installed and is being used on the playground, that equipment, that it sort of fits standards that we now accept for playgrounds, for recess equipment, that just because, you have swings, let's say, I trust most of you still have swings. And, well, a student jumps off a swing, and I trust many of you probably talk to students, hey, let's not be doing that. But even if you say that, they might still go ahead and do that, and they jump off the swing and get injured when they jump off the swing, even though you had shared with them not to be jumping off of swings and so forth. But you followed good practice installing those swings. You made sure that those swings met the standards that would be recognized sort of throughout not only the state, but likely the country, relating to construction and maintenance of that type of equipment. And because you did that, there's going to be immunity even though the student was injured there. So that would be another example of sort of broad immunity that's applied for school districts themselves. Beyond the district, let's get into a little bit with, and this is one of my key points when I say the love-hate, is, I realize that sometimes your employees, your teachers, your coaches, whatever, they get worried that, well, am I going to get sued? Is something going to happen to me? A child gets injured in my class or on my team, and then are they going to come after me? And they might try to do that. I can't promise you that a parent's not going to try to do that, but those employees should be reassured that Iowa Code 670-8, and this has been in the code for decades, provides protection for those employees, and the district has to defend those individuals. So if they're operating in good faith, they're carrying out their duties in good faith as a school employee, and this includes you as well, for the school administrators that are listening to this, that the district has a responsibility to provide legal defense for you in those instances. But beyond that, you are not able to be found to be personally liable in most any instance, and again, as I put it, where that employee is carrying out their job in good faith. Now, where an employee might be liable would be if they did something malicious. They got angry at a student and they did something in a manner that's outside of the expectations for school employees. They're likely violating BOE regulations as far as standards, ethics standards at this point. They did something malicious toward the student. Well, that's not going to be protected. There's some going along with that. There's some willful and wanton or reckless conduct. They allow students to maybe, to the reckless point, they allow students to do something in class. They're trying to be sort of buddies with the students, and they allow them to participate in something in class or outside or during an activity that employee should, everyone sort of knows, well, that's common sense would tell you we shouldn't allow the students to do that. The employee saw it. They should have stopped it. They sort of knew they should have stopped it, but they allowed that reckless conduct to go on. Well, then there could be some liability there for those employees. So those would be examples. But again, in a vast majority, and I've said this many times, I've spoken, had the opportunity probably to speak to, I don't know how many thousands of teachers over the years, where some of you invited me out to your district. But I reassure them about this point, that I know that most of them are trying to carry out their job in good faith. And despite them doing that, injuries still happen on occasion. It's going to happen. You all know that. And so just know that there are those protections there, not only for the school district, but also for those employees. So let me give you some other examples relating to liability. Let's discuss sort of some specific examples where districts have been found to be liable for injuries to students. Usually this has related to circumstances, and while I talked about that discretionary, that immunity for discretionary functions concerning to supervision, again, that only applies if the district is following those standards for supervision. Where there's been liability is often related to a lack of supervision. So your expectation is that you have 4 employees out on the playground during recess, as an example, but instead there's only 1 employee. If there's only 1 employee, and no district out there is going to send 1 employee to supervise if you have a large number of students out there on the playground, no one would expect that you'd only have 1 employee to try to supervise a large number of students out on the playground. Well, if a student gets hurt, you're likely, the district anyway, is likely to face liability in that instance. Let me give you another example, and a couple examples that would come up with supervision, and so to distinguish sort of the different risks that are involved in particular classes. You have one class, let's say you have an English class, and there hasn't been past fights in the class, there hasn't been past sort of horseplay or other behavior in that class where it really hasn't been an issue that's been raised in the past relating concerns about injury to students. And in that English class, then if someone comes down and wants to speak briefly and pull that teacher out of the classroom just to go out in the hallway, they're still within earshot of the students, but they're going to step out in the hallway and talk to that English teacher at that point. They go out in the hallway, and then unexpectedly something happens in the classroom. They hear this, they go back in, and then there's some injury has occurred to a student relating to some horseplay, as I put it. I don't see there being liability there. Are they likely to come after, try to get some money out of the district? Probably. I see protection in that instance. Now, let's shift from that English class to a shop class or whatever you want to call it. And students in that shop class, they're working with saws and electric saws, and they're working with things like that. And while they're actively working with this type of very dangerous equipment, well, I think that's something quite different than for at any point for that a teacher to be leaving that classroom and for them not to be supervising these students while they're working with this very dangerous equipment. And so in that instance, they step out, student unfortunately cuts themselves on one of the saws, does some real injury to a finger or something like that at that point. Well, there you're likely going to face some liability there in that instance as a district. Okay, so those would be some examples I'd give sort of on the classroom side. Now let's switch it over to athletics. And as I mentioned, yes, there is some protection with assuming this risk for recreational activities, but supervision likely looks a bit different for the cross-country team, as an example, as opposed to a football team. All right, so there may be instances where that cross-country coach reasonably allows, or a track coach, and they're allowing the students are just out running, and they're running on sort of what seemed to be a safe course, or they might be on the track, or whatever the case would be. And while of course they should be trying to supervise them best they can, but there wouldn't be an expectation, I would say, as of the same level of direct supervision on those athletes as opposed to the football team. Now, no football coach that I'm aware of, let's say they're doing tackling drills, and I know you don't do as much of the sort of full contact in practice, probably like we did back in the 80s, and that's probably a good thing. But let's just say they're doing some type of full contact drills, they're tackling, they're working on their tackling and doing full contact. Well, that's quite different. No coach would allow those football players to go, well, I'm going to step over here and I gotta run in and use the restroom, and just you guys keep on with this tackling drill while the coaches go and meet for a bit off to the side, or someone has to run the restroom and there's not supervision. Well, of course not. And so those would be some examples there, and hopefully you're able to distinguish the difference there where there's likely to be more liability, or the likelihood of liability with that activity, because of course it's a more dangerous activity, and the expectation there would be additional supervision. Another area we've seen, and this sort of goes to the supervision where the district has faced liability in the past, has related to your attendance and communication of attendance to parents or guardians, or lack of attendance. And so this is something that we saw a number of years back. It was probably about 12, 15 years ago. We're in Iowa school district. There's a student. The student knowingly skipped class, but the court found that the district should have done a better job of communicating that in a more timely manner to the parent or guardian. Now, I know that most of you, if not all of you by now, have good systems in place where you get, I've certainly gotten text messages over the years from my children's district when they were younger. Hey, your child's not in this class, or they were absent for this period. And you might have text messages that go out, or some type of automated call that goes out. Well, that's likely going to be enough to help to provide some protection. In that instance, though, the district had not communicated immediately that the student had, frankly, skipped class with some other students. And then very sadly, during that period where they had skipped class, a student was sexually assaulted during that time. And the court said, hey, you do have liability here, school district, because you should have had better communication. Again, this sort of relates to supervision and communication with the parent or guardian. So that would be an example where there's been liability. Another example where I'd share where there's been liability, and hopefully we're not going to see as much of this now with some of the expectations with background, not only with background checks, but the reference checks that you all are making now and so forth, is if a district hired someone, and this has happened in the past in Iowa, where the district hired someone, well, it turned out that employee had previously had sort of misbehavior with students in the past at another district, and the court found that that school district that currently employs them had not done their due diligence in looking into their background. If they had done that due diligence, they would have found out that there had been this misbehavior, and the expectation would be that they wouldn't have hired them and so forth, and thus put students at risk relating to the misbehavior of the school employee. Again, that one hopefully we're largely solving with a lot of the expectations now with background checks and also with reference checks. But those are some examples where there's been liability. So I've sort of gone on. I think you get the point. Again, my focus and my encouragement as far as areas of liability is particularly focus on supervision, as I've been talking about. I mean, that's the area where I absolutely would just make sure, and again, it's not about that 2 staff members to every student crazy example I gave on the extreme, but just doing your best to consider, well, how many employees do we have relating to, and of course always weigh what is the potential risk, or do we have some known risk? Do we know that 2 students have sort of gotten into an altercation in the past, and now that we have this known risk, there'd be some additional expectations relating to possible additional supervision of those 2 students who've been in an altercation. Maybe have an example where a student was injured out on a playground. Back to the playground example in recess, you have an area on your playground where students were able to sort of go over and get behind some bushes, and they really weren't able to be seen, and some injury occurred to those students when they went in that area behind the bushes. Well, the expectation, of course, would be that the district would do its best to make that area off limits. Hey, students, you're not supposed to be within 10 yards of those bushes, let alone to go behind those bushes. And the expectation would be is that you would share that with students so that they know they aren't to go in that area. You know, that would be an example where there'd be that expectation upon you. And of course, you pass on to your employees to put those areas off limits that relates to past injury or past misbehavior of some sort. So just constantly just be reassessing these things. But the bottom line is, I would say that most of the time where there's some sort of injury of a student at school, neither the district or the employee, and especially employee, are going to be liable for that injury. So just hopefully you find some comfort in some of the things I shared and able to pick up on some of the other recommendations. But I just wanted to talk a bit about this because I think that we get so worried about liability at times that we sort of get away from some of the other parts of the educational experience for our students, where we make it so vanilla. We make it, where we're taking away a lot of the things that maybe are reasonable things to allow for them to exercise, for them to recreate in some way, them to interact, and just know that, again, there are protections there. So with that, I hope that you are all doing well, and hopefully we have some good weather here during the spring. I know it's back and forth. I appreciate all of you and what you do for Iowa students. If you have any questions, whether it relates to this podcast or anything else, give me a call at SAI 515-267-1115 or shoot me an email at mcarver@sai-iowa.org. Thanks so much.